talk with Chris Wheeler and everything regarding this, and were you on that conversation?
I don't remember.
Oh, Brian, you were on that conversation. The conversation went that we were going back to try to get the soonest date on the filing and correcting the provisional to encompass all of these things, since we...
Well, you can't correct the provisional, but you can... What it does is it claims back for everything that references back to the original, but then incorporates all the new elements, which to bring it in, to make it into a more complete statement.
I'm not sure I understand this. It was my understanding that we were going back to Ray Joe's patent and fixing it by inserting what we have here. When I talked to Doug, that was what he's under the impression we were going to do, and now that's all changed as of today.
Well, you really can't fix a provisional application, but
Not the provisional, the Ray Joe filing of August, whatever day it was.
No, it's in March.
Right.
March 24th.
oh, okay. Yeah.
And that way, if that patent gets approved with all this in it, that's what we were doing, and we wanted that one to be approved first correctly, because it obviously expedites our life by a long way.
This is the PCT application filed March 23rd. Is that what we're talking about?
Yeah. Well, but the way that I recall the conversation, the spec, of course, cannot be changed.
Right.
But the claims can be.
Right. And they can be changed so long as they're supported by teachings that are in that specification.
Right.
Which is why you really, I mean,
And the specification can't change?
No.
Correct.
Why?
Because it would be kind of like,
I thought that was based on new matter.
well, exactly. That's exactly why it can't be changed.
But so it can be changed if it's still the same matter.
The claims can be amended so long as they're still fully supported by the matter that's in the specification as originally filed. Now, if you want to change your claims and they're not supported by the specification as originally filed, then you have to file a whole new application adding new matter to your specification that will support those claims.
Does the fact that a direct interpretation of what in general amounts to typos and oversights, but a direct interpretation of that affect our ability to, or to change that supporting matter of that matter? Because if we directly interpret the math in the certain circumstances here, it will bring you to a wrong conclusion if it's a direct interpretation without having to reverse engineer what was meant to occur.
Well, I see. Then we need to get math right, but it doesn't affect our priority. Only by a few days, essentially. I mean, if we...
Well, do we lose the ability to claim priority to what we were trying to claim to?
No.
By that date. So you can go back in and change the matter of this.
Well, you don't go back and change the matter. You just file a new application which claims priority back to a prior application only for the subject matter that was...
But we missed that application.
No, we've got it in the form of this continuation, or this PCT that we filed, claiming priority back to that patent application. So we preserved that chain of priority.
Are you then completely confident that errors that we need to correct right now are then not going to hurt us in any way, shape, or form in being able to claim as part of our invention all the correct things that we want in here?
That's what I heard at that meeting. That we could go back and redo that at a later date without having any implication.
As long as it wasn't new subject matter.
Exactly right. These are just corrections to the...
So they're either corrections, they're math, or whatever.
Okay, but it's not. We're not saying this is a new way to get to that.
No.
Okay, that's what I heard. That's the notes I took. Elliot, you should have that on a tape recorder so that we know that.
Well, we do.
beyond that, Doug, what I'd like to really get down to is a letter from you, in writing, explaining all of my, both from the Ray Joa patent forward, and I think you need to talk to Doug about it, of what our potential pitfalls are here with this filing years, what our potential pitfalls are, what it caused to happen, what that priority equals, and if there's any harm to us. Because we keep just slipping back by these things. This should have been right. I mean, we have well documented, and Brian's well documented, that these changes were sent. And now we've missed a priority claim to that by not being able to go back and change our last filing.
Brian,
I need to know the liability here from us.
I wasn't obviously there Wednesday night. Brian, did you Doug on this and make final changes and then...
Yeah, Doug sent me a next to last copy, which I went through, and there were a number of errors. I have my notes on those, each one of those at home. And then I reviewed each one of those with Doug, agreed on what they were, and then Doug was going to send me the last copy, which apparently he didn't, because I never received it. And at that point in time, it was about, my guess is about 11:30, 11:45 our time.
And these were also discussed in great length with him for a whole day on the phone.
Yeah, well, how about in the
No, Dad, this is separate.
Oh,
But at great length, this was discussed. Every one of these changes.
oh, is that the changes you sent me here? Is this Brian's handwriting?
No, some of it isn't correct.
Well, let's go through it, because I'd like to get
let's go through it.
Okay.
All right.
Well, I don't know if that's going to help that much because it's a question of, what actually was filed and whether it incorporated the changes that Brian asked in the last minute.
It didn't.
We know that. This is what was filed.
All right.
I thought, Brian, didn't you just say that Doug didn't send you the final draft of what was filed?
The next day.
Oh, he sent it the next day.
Yeah, Jim, can you forward that to Steve real quick?
What?
Email it to him, the final draft.
Yeah.
Okay.
Okay. Well, I'm not gonna question.
Okay, but we need to go through and get the changes acknowledged, accepted, have you put it into the next, whatever you're going to do to solve this, with a letter explaining what we've lost here.
All right.
Okay? Any liability, potential liability we're exposed to from this.
Oh, I wouldn't worry about it. You're making it much.
Well, I got to tell you, I worry a lot about it from what Doug told us.
Yeah.
So, you know what I mean? You tell me not to worry, but then you tell me it's very important that we're accurate in this filing, and then we're very inaccurate in the filing, and then we're not supposed to worry. So I'll feel much better not worrying with a letter from you explaining why I shouldn't worry.
Steve, what's your email?
S. Specker at Foley Law, FOLEYLAW.com.
S. Becker.
Yeah, S is in Stephen.
S. Becker.
BECKER.
Got it.
Right.
Okay, and let's just go through this with you, Steve, so we can get the next step done,
All right.
which is correcting the issues. So, are you with us on page 13?
Right.
Okay. Jim?
On page 13, line 19, the expression of VWH, you follow the way we express it in our definitions, which is VIH.
Okay.
Even though the two are equal, it should follow the way that we have it expressed in our definitions on page 12.
Oh, I see. Okay.
1789 divided by 5.
Okay, hold on. Let me look. Scan density is, what's the rest of my patent? Defined by us as being, let me look here. Where the heck is it? Oh, it's right up above. Target image height, right up above on line 7. Maximum scan density is target image height, which in this case we've just defined to be 1431.
Where are you reading from?
Line 7 of the same page. Line 7, page 13. So target image height is 1431 divided by the source image height, which is 4. So it should be 1431 divided by 4.
Well, I guess that that equation, MSD equals TIH slash SIH, did not come from my documentation.
Hold on, let's look at your documentation. I've got it right here too.
Well, Doug, Steve, you have copies of this too. They were sent to you.
Right.
Of what Brian's looking at several days ago. So how isn't this stuff flowing forward into the patents? And especially when we pointed it out 2 times before filing. I mean, I'm just dumbfounded at this.
Well, there was a change, Steve, which you were not involved.
This is the proper equation.
Steve, there's a
I wasn't
change.
there the last night when the last changes were put in, so I can't really speak to it.
Yeah.
No, but he sent you his changes several days ago.
Steve, there was a change that we decided on Wednesday afternoon, which was to reflect aspect ratio as width divided by height, which I made, and that was created by the desire to reflect aspect ratio the way that displays are expressed, as opposed to the way photographic images are expressed. Photographic images are expressed the opposite way, and that's the way the documentation had been originally prepared. But it was felt that it was perhaps more consistent with current technology to express it the way that displays are expressed. So I went through and changed.
Coming from that change in convention?
Yes.
Right.
So that caused the equations to be reconstructed to reflect the inverse of what was there before, because the aspect ratio now is inverted.
I see.
And what happened was Doug apparently did not pick up all of those changes, even though I went through them very methodically last thing Wednesday night after he sent me his almost final draft.
I see.
And Jim, just for your edification, that also affected the MSD, shifting from a height to a width orientation. The number is the same, but it changed it from a height to a width.
So what's the correct formula for MSD?
It's TIW slash SIW.
Okay. Target image width 17.
So wait, you made this change with Doug, and it's still wrong in the patent.
Right.
Okay.
I'm a little concerned about the proficiency of the legal aspect of this. We sat there for hours, and then Brian stayed late to the night with this guy, and then he comes back and we don't file it right anyway. It seems like there's something wrong here.
I mean, this is, yeah.
I'm just butting in because I have little or no knowledge as to what the numbers mean. the changes, well, what's the sense of that?
These are good points.
Well,
Let's move forward, Jim.
These are points that have to go back to stockholders with money in
Well, that's why I've asked Steve to send us a letter of what's happened, what our exposure is by, like Monday or Tuesday, explaining how this didn't occur, get in, and what we're going to do to resolve it, and what that resolve initiates in chain of events.
Well, the other side of it is this. If after all of this precaution has been taken, Brian, you correct me, if you think different, but after all this precaution has been taken, it appears that the fallacy of worry about it ever gets accomplished. Brian stays, everybody works on it, it's still filed wrong. Now, what if Jim Armstrong hadn't caught it? Brian was on a plane today.
But none of Brian's changes even sent several days ago would have even been in there. Math would have been wrong. Equations would have been wrong. Verbiage would have been wrong.
Am I right, Brian, in getting this and having this concern?
Well, yeah, obviously it's clearly a major concern because there's nothing more disciplined than the mathematical expressions.
And you're comfortable that what you did, even if some of them were wrong, that we could have later corrected?
No, Dad, we sat here with Brian and Jim and Doug, and we went through it, and we all agreed it was right, and those changes do not appear.
Yeah, no, we...
that makes me very nervous. I mean, it makes me nervous to the extent that are all the other patents done right?
Well, that's what I'm going to start having somebody review all this. I mean, obviously this opens up a whole can of worms.
Well, the other thing that I heard was, and not negatively or anything else, but I heard that, perhaps Ray Joa did this work and he was, either concerned about costs or a bit sloppy, blah, 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 blah. What is the excuse of this law firm?
Well, let them write us what's happened here. I mean, I definitely need to see in paper, Steve, some kind of report on this, that it describes what occurred, why it's not reflected in the patent filing, and what our exposures are. And that'll tell us, what we're dealing with in firm, etc. Liabilities. I mean, we don't know that yet.
We should continue to look at the changes so that he's got a copy that reflects everything.
And even if there is no liability, what I'm so concerned about, even if it can be corrected, it's the exact same position, Brian, am I right, that we found ourselves in with the last lawyer who did it. Okay, thank God we can make changes, but that isn't the answer. Why not just get it right, get it filed?
No, don't just say, thank God we can make changes, Dad. Because all of that brings additional liability to you. You miss dates, you miss claiming, you miss this and that, words that are very tricky and confusing and only these guys can understand. So that's why it needs to be put in writing so we can have it analyzed.
Absolutely, I want it definitely because I need to take it to, I have to have board members' approval.
Oh, I think our board is going to be disastrously pissed off about several things when we take this to them. And we need to know from the Ray Joa level to the Foley Lardner level how this, is going to be cleared up and what the problems were that occurred.
Okay, well, let's get that part in process. And it's unfortunate that Doug's not here because maybe it's something he could explain, but he's not.
No, I talked to him this morning. And as a matter of fact, he said, Steve had the math from Brian days before, and, by the time he got it, he thought it was all input correctly, and that was his excuse.
Well, what was he doing here with Brian?
Well, then we spent a whole day with him correcting it all so that it was right, and then by filing time, none of it was right.
Okay, listen.
So let's go forward. Let's just stay on track. We'll deal with all these issues on Monday.
I just say one thing. Fortunately, I don't know. The most important part of the math is all of the definitions. The examples are examples, but the most important part of the math is are the definitions.
Okay, are those right?
No. Well, there's one that's not. We just found out. Line 7 of page 13
is wrong.
It's wrong. It
two they're mathematically equal. Both will give the same result. So it's a consistency question as opposed to an accuracy.
For a reader, it'd probably be easier to be consistent.
Absolutely.
And that's what we want. We want, as long as we're spending all this money and everybody devoting their time to it, we want it to be right. As right as you can possibly get it, at any rate.
Right.
Okay, good. Let's move forward then.
That changes one thing on line 25. The expression on line 25 is now correct, as it was typed. So scratch out my handwriting.
All right.
Okay? All the other corrections stand as I explained them earlier. Now on the last line of this page, that should read 480 by 320.
That's correct.
Okay? And then in line 6 of page 14, I think we should consistently state which width and which number is height, because it's such an important distinction in the calculations. We did it on the previous example, but not on this one.
This is width height.
Yeah. Width and height.
Width is, height is 4.
That was what we had agreed upon on Wednesday afternoon.
Right?
That changes in that.
Line 17, again, we're just missing that square root symbol in order to make that equation work. Without the square root, it's millions instead of thousands. Now, in line 19, I had originally indicated this was correct. It's now incorrect because of our change in the formula for the density, for the maximum scan density.
Steve, are you getting all these?
Yep. This should now read in line 19, 1789 divided by 5 equals 358.
1789 divided by 5 equals 358.
Yes.
All right.
Steve, I have a question to ask you.
Yeah.
When Jim or Brian or anybody gives you these numbers, are they checked out by anybody, or do you just copy what we say and that's it?
Well, no, they definitely don't copy what we say. That's an initial problem here, Deb.
No, I mean to be sarcastic.
No, but they would normally, as mathematical people, add up the equations.
Yeah, because your partner was telling me that most patent engineers most patent lawyers are engineers, which would lead me to believe that somebody would say, well, I better check the math to make sure that guys who are not engineers know what the hell they're talking about. Is that done by your firm, or is it just accepted as gospel as what we give you?
We don't have engineers or technical people check the math that you provide us.
Okay, so what we provide you then, we live and die by.
Right.
Okay.
That's your job is to get that right.
Right, but what we did give you, you didn't provide in the past.
Okay, wait, we're saying the same thing.
Okay.
I mean,
Let's just get it right.
Yeah.
Okay,
At this point, we're only interested in getting it right.
line 27, that should be 360H. Okay, for the height.
Which page, B?
Line 14, second to last, third to last line, the H.
Okay.
And then now on to page 15. Again, we just need that square root symbol as indicated there.
okay.
All right. And then, actually, there's nothing on the next few pages until we get to page 18. And this is an important omission from a calculation standpoint, but we need that square root symbol.
Okay.
And then I'm going to skip for a second the discussion on minimum scan density here because I want to talk to what Brian commented too. But on line 10, the correct figure is 1.33 equals 1.33.
Okay.
Yeah, that wasn't picked up from above.
Right.
The window aspect ratio.
Line 15, the square root symbol again is missing from that same equation. And then finally, I don't see why it is in this example or any digital example where we have no scanning to do, why we should even include any reference to minimum scan density. Because the only
add anything. It doesn't subtract anything.
It had a confusion to me as a reader when I thought, how do I calculate that, and then realized it's not important because we're not scanning anyway.
Right.
Why ask someone to determine something that is not included as a step of the process? So I think if everyone agrees, we should strike the words "and minimum scan density" in line 1 and 2.
Now, what I would do, I wouldn't do that. What I would do is simply say, determine the target image size and dimensions, and then add a new sentence which says, minimum scan density is not required since we are dealing with a digital image.
That's fine too. And then strike line 23.
No, I'd leave that in.
Okay, it's redundant, but that's okay. Do you see any other problems with the formulas? Did you review all this again today, Brian?
I've not reviewed anything today. I wasn't aware of the problem until about 3 minutes ago.
Okay. So that covers my comments on that.
And Steve, do me a favor, when you guys draft this letter, draft it to sign Brian.
Okay? You get it.
I'd like to be CC'd on, and by the way, I'd like to be CC'd on any correspondence of anybody to do with the patents.
Okay.
One last thing. Doug mentioned that you had a file from Brian, a spreadsheet that part of the spreadsheet matter is not incorporated in here. He didn't know why. He couldn't explain why. I was wondering what that matter is. Where is it? Are you aware of it? Because he referred to you.
Okay.
Yes.
That's probably the image sizing spreadsheet.
Image sizing.
Yeah, I sent you 2 files on Monday.
Okay. Actually, I think you sent 3 altogether. You sent 3 emails, and then the last one had 2.
Right, that's right. The last one had 2 files, both the image sizing and the process.
Oh, you've got the macro, and then you've also got
Right,
description.
right.
Description of the math. Now, what did you want included that wasn't?
Well, Doug said it should have been included, but it wasn't. The rest of that sheet.
One.
Whichever half's missing.
No,
Hold on 1 second. I don't want to confuse Steve. We do not want you to cut and paste out of those documents into the patent filing. Those documents do not reflect the way we want to express the math.
Right, but we might want them in there be correctly.
What?
We might want them
Now in there correctly.
What?
We just went through it. It's now correct. If he employs all of the changes we just all agreed to.
No, but there's another sheet that's not reflected here.
Well, yes, I do want to talk about that. The macro, right?
Right. Can you forward that file to us? The Excel sheet to Jim, me?
Just have Steve forward the whole email back to you.
Well, he does have it in front of him, and Brian's got it right here.
No, I sent it to you.
Okay.
You were copied on it.
Let's just get the most up to date. Any changes?
Yeah, Brian, remember, you may recall, we made a decision not to file the claims directed to your macro. We made that decision last, a week before the...
Why?
Because it was going to involve some additional work, and we didn't have time at that point. And with all new matter, it wasn't going to claim priority to anything, so...
Well, what's new matter? If the math is part of describing the invention, then it's not new matter, according to what Doug's told me 4 times now.
Well, Elliot, as you recall, you always have to look at the claims of the application, and that defines the scope of your protection.
not new matter. It's just an understanding of the matter. And I mean, I swear we went through this 4 times the other day with that conclusion.
There were 2 files that Brian sent me. One of them was an Excel sheet having 6 pages. And all of that material was included in the application in pretty much cut and paste format. At least pages 2, 3, 4, and 6 those were the examples, which I just cut and pasted as soon as I got it from Brian, because
Which ones are those, Pat?
he defined it all very particularly.
Okay, now you need to keep accurate records of that, because 2, 3, 4, 5, and 6 that Brian is sitting here showing me were never in these patents yesterday. So cutting and paste, you must have put them in a wrong document.
Those are the examples.
But those weren't. That's not what ended up in there.
These they pulled these pictures out, put them as a figure sheet in the back, and then re-entered separately
Wrong math.
the formulas in the body of the
Hey, right, B, are those images? Are you looking at the figures? And are all these figures in the patent application now?
It should be on figure 7.
The figure 7.
Okay.
Are you looking at it?
That's in front of me, but I recall writing it.
Jim?
Oh, what do you want me to look at?
Figure 7.
Yeah.
What do you see?
No, I don't have a figure 7. Oh, because that was part of, that didn't come in the patent application that I was mailed.
It's not part of that final patent.
I don't know about that, but it didn't come as part of that Word document.
Well, that's what I just sent you.
What?
That's supposed to be the final revision of the patent.
We didn't scan the drawings into Word documents, so if you just mailed a Word document, you probably didn't get any figures.
Yeah, probably the figures were left off of that out.
Okay, do you have your patent application?
I got it to show. I got the one we reviewed on Wednesday.
And what's in there?
All the figures.
Right or wrong?
I don't know. I didn't, Brian, would figure 7 change at all with the restatement of how aspect?
Yeah. There were some additions that I made for clarification purposes. If you look at the first page of the imaging process, where it says the third box down, where it says viewing image, I inserted SIR less than VWR to tie it to the equation above it. And then in the one on the bottom, it has the expression SIR greater than VWR. Again, that is to tie it to the equations above it.
Yeah, because those two don't have a distinction in figure 7 as it is now.
Right. So that simply ties the image to the equation.
So do they have you sent them an updated?
Yeah, that went out.
Of them?
That went out late Wednesday afternoon.
Okay, so we just got to make sure that the corrected figure 7.
Steve, can you fax us the file patent?
No, I can't find it. Doug took care of this from
Does his secretary have a copy?
Monday night on. I spoke with her, and she wasn't clear. She wasn't able to find it.
Do we have a file patent?
How certain would you like me to answer that question? I mean, Doug sent me an email saying we filed a patent.
Well, what he sent me that he said he filed is missing the diagrams. So reason to get upset until I see that I spend a lot of hours going through this. Brian spends a lot of hours. We make all these global changes.
Elliot, I've heard that a couple times already, but
Yeah.
let me try and explain a little bit about patent law,
Okay.
and maybe help everyone understand what has or has not happened. Okay, there's a lot of rhetoric being thrown out here, but there's
Well, because we're blind.
I don't think all of it has I don't think all of it has a lot of basis in patent law.
Well, that's good to hear, so let's hear that.
Okay, I thought you in particular might be interested to hear that.
Yeah, that's, I'm not sure that has any comfort, because maybe what you're saying is it's not an exact science and that you move along, but
I'm going to go well beyond that.
okay.
All right. Does anyone have a copy of Claim 1?
Yeah.
They can read off of?
Yes.
This is only a piece of it, right?
Yeah.
Page 22.
I'm working off what you emailed me, Jim, and I see page 24, lines 1 through 7. I guess it could have repaginated, but...
Oh, but it mailed you or faxed you.
I'm sorry, what you mailed me? Emailed me. Didn't you just email me?
Oh, okay. Okay, may have changed then.
Yeah.
I don't know why though.
But the top of the page says what is claimed is.
What is claimed is.
You have that?
Yeah, page 22 in my printed one.
Okay.
Okay, wait, hold on one sec, because I want to get my notes here.
What page is that, Jim?
Page 20. You don't have it.
I don't.
Oh, you don't have it.
Oh, it's because I don't have 22.
You want me to fax it or email it to you?
No, that's okay. He's going to explain it to me. I'd rather see if I can't understand this.
Sure, it's a very short claim. Just seven lines long, and it essentially defines the scope of the patent protection that we are trying to obtain in this filing.
Yeah.
Who are we waiting for, Elliot?
I believe so.
Yeah, we're waiting back for Brian again.
Guys, let me know when you're ready.
Okay, Steve, Brian stepped out for a minute, but I still want to address this issue. We invent something. I hire a mathematician. The mathematician solves the X, Y, and Z of the invention. Does he claim a new patent for himself?
Probably not. Inventorship typically follows with the conception of the invention. If somebody else figures out how it was done, generally speaking, that would...
Well, I want to be very clear on this, because Doug's thinking that. Now, I don't even know if then the next statement is correct or incorrect, but if a macro was created using the math that comes from the invention, where does it follow? Brian, I just asked him, if I hired a mathematician to do the math, put all this into a thing, where does this follow? He says the invention, the inventor, etc. The guy who hired to do math wouldn't claim a new patent or a new invention, which is confusing to me, because Doug now, as of this morning, told me that you're planning on filing a separate patent as inventor of a macro that spawns off the math entitled to this invention. So I'm confused, and I want to be very specific on this, of what our strategy is here on all of these peripheral pieces.
Yeah.
Okay. Why don't you explain that to me again?
Can we go ahead with the describing the claim?
Well, do you want to just finish that real quick, and then we'll go right back to the claim?
Okay. All right. Now, what is the question you're posing, Elliot?
I hired a mathematician to solve for what I did. He comes up with an equation. Where does that equation belong? Does it belong filed as another patent? Does it just... what's the inventorship, so to speak? And then I designed from that math a macro that solves that math with input formula. How should we be protecting that the whole way through? Because I seem to be very confused about what I'm being told each day.
Okay, let him answer the question.
Yeah, inventorship follows whoever conceived the invention as claimed. And that's why the claim is so important, because when you set forth in your claim what exactly it is you're claiming, you have to ask who conceived of that idea, who was the first one to come up with it. So, typically, if somebody merely reduces your idea to equations that describe, why it works or how it works, typically they would not be named as a co-inventor because they really didn't invent the idea. Now, if you wanted to claim a macro which has user input displays for receiving certain data that can be used by, say, a technician to determine the scan density of a print film image that would allow for the desired enlargement ratios and for the desired target image size. That kind of is a separate idea, and that's why we thought it might be useful to claim that as a tool as well.
Okay, and I understand that part. I don't mind claiming that all day long.
Right, and Brian really, was the one that built that, came up with it. It's based on principles that you learned, a few years ago that maybe you didn't understand the math behind them, but, certainly Brian would be, I would think, be named an inventor on that.
Yeah, I think that would probably properly claim both Elliot and myself, since it relates to both aspects.
Right, but the important thing with the patent office is that the patent office realizes that it's a bit of a gray issue in terms of who conceived what, and so the important thing is not
Between inventorship and ownership, as I understand all of this, every one of the patents that we have filed, all rights, title, and interest, are I view it, regardless of who the author inventor is, and any revenue streams derived therefrom are I view it, and that's the important thing. And is that true? Despite and in light of the
Well put, John. That's my very next question.
because we could put anybody as inventor, but as long as that doesn't entitle them to a disproportionate share of any revenues derived therefrom, then I don't care.
Yeah, inventorship or ownership initially vests in the inventor or inventors who are named in the application, but typically inventors are under some obligation to assign to a corporate entity, either written or by cause of their employment. And you can get into issues of shop right if somebody invented something on the corporate time, but then went and it wasn't really part of his job description, and those issues can be a little more tricky. But I think in this case, and what we do typically as a practice to confirm ownership is we have the inventors sign a written assignment document over to whichever corporate entity they want to.
Have we followed that?
We've got those documents. I don't think we've had them all filed or signed and filed yet.
Let's get them.
Oh, Doug was doing that on Tuesday while he was here.
Okay.
Did you do some signing of documents?
Yeah.
And then Elliot?
Right.
Okay, so that's in process.
Okay, and that wasn't really the intent of my question. The intent of my question is to define, from my understanding, what should claim back to Ray Joe's patent. And that means that everything other than a macro shell should define back to the original patent and be filed, corrected, amended, however we get it in, to the original patent document, since none of it's new matter. It's just an explanation mathematically on every equation of what happens.
That's what I heard at the meeting.
And that is exactly what I've heard, repeated, and then this morning it was completely opposite, and yesterday it was a little opposite, and I've become very confused about which strategy we're taking, which road, because we decide something, and then it's changed, and we're doing something else, and I'm completely lost.
I think I can make this very clear for you if you'll give me an opportunity.
I will.
Okay. Let's take a look at Claim 1.
Okay.
Claim 1 states that what you're claiming is a method of providing a digital image file for viewing on a user display. a digital image file having an image size comprising a fixed number of pixels representative of an image, wherein that image size is greater than that of the viewing window size. Now, the broad concept that we're trying to claim here is being the first ones to provide a digital image file that has more data than is needed for the window size. And why are we trying to claim that? Because that allows you to zoom into the image without pixelation, and it allows you to pan around the image to corners that maybe are not shown in the original viewing window. Does everybody understand that?
I think so.
Yeah.
I think we're on the same line.
Okay. All right. So now the question becomes, did we support that claim
Right.
with relevant description in the specification?
This was the final.
And what's our standard? Our standard is that we have to provide enough disclosure in the specification to enable somebody to make and use that invention as claimed. And we need to, this person needs to be someone of ordinary skill in the art. In other words, somebody who can read this document, is maybe has some technical background in imaging or image processing, for example, and can read what we've put in our document and perform our method claim. Okay?
Yep.
Everyone with me so far?
Mm-hmm.
So we look back into the document that was filed on Wednesday, and we say to ourselves, did we provide enough information in that document to allow somebody to teach somebody how to make and use a digital image file that has an image size greater than the viewing window size? And one might argue that stating the solution in itself almost provides enough information to one of ordinary skill in the art to actually reduce it to practice and to make and use one. However, we've provided not only a description of several different ways of doing it, but also some examples, including math, that should make it abundantly clear to one of ordinary skill in the art how to do it. The test is whether it would require undue experimentation on the part of this fictitious person of ordinary skill in the art to make and use a digital image file having these characteristics. So the question you need to ask yourself with respect to this application is, okay, maybe there was an error or two in, how it was expressed in the examples, or the number of pixels counted, or a division here or subtraction there. But was there enough in there to enable somebody, based on those teachings alone, and of course their background, to make and use an image file having those characteristics?
Okay.
Okay? And I think, based on a reading of it, and based on what Jim just walked me through in these corrections that need to be made, that there probably was enough in there. That there probably is. I mean, we've described in several different ways how to do it with print film images or with digital images. We described it generally, and then we went and described it specifically.
Okay, Les, can I ask you a question?
Wait, Dad, because that still didn't answer my question. That answers this issue here.
And let him finish it then.
Okay. Are you going to take this back to Ray's original filing?
Let me do that next.
Okay.
Okay? Now, with respect to Ray's original filing, on August 2nd of last year, we asked the exact same inquiry that we're asking when we review the specification that we filed on Wednesday. Did Ray's filing back on August 2nd of 1999 provide enough disclosure and enough teaching to enable one of ordinary skill in the art to make this file?
And we have a lot of disputes on that because it doesn't even cover zooming.
Right. But what it does describe, if I recall correctly, is it does describe that you want to enlarge a print film image to a certain size and then scan it at a high density. Now, it doesn't tell what density. It doesn't give a number of pixels.
Doesn't talk about zooming in on the image.
Doesn't tell the
processing said digital signal file and for generating an image file, wherein said processor generates a first signal file from said digital signal file, and further wherein said processor processes said first signal file and generates said image file.
Okay.
Okay, we all agreed that that is completely insane to describe anything about our invention, the whatever.
I won't call it completely insane, but I think that with the claim that we drafted,
Yeah, he missed the point. Okay, well then the claim we drafted, this was my question, should be right here. And this claim in the patent he filed to date back as far as I can to protect our dates should be changed to the claim we just created.
oh no, this application died on Wednesday, and it doesn't proceed to a patent. A provisional application.
No, this isn't provisional. This is a filed patent I'm dealing with.
This is the one that was filed March 24th.
Oh, okay.
By Ray Joa.
So this was the PCT filing on March 24th.
Okay, thanks.
And my question is, shouldn't the claims in this patent we just filed be exactly, if not identical, to the one, or should they be transposed to Ray Joa's? And it was my understanding from Doug that for speed and if the patent gets through, etc., that we would rather have it be based into that first patent filing. Otherwise,
That could be a recommended course of action.
and this is going to get dejected.
What we discussed on Monday afternoon was that one of our action items was to go back and review the March 24th filing and decide exactly how we were going to integrate into that filing the claims that are that should be in there vis-a-vis the specification.
Okay.
That was one of the action items that we covered on Monday afternoon.
And now my question, wait. My question further goes to say that once we amend the claims, is there any way to amend the body?
No.
Even if we're not adding new subject matter?
You can amend the body if you don't add new subject matter.
Okay, so we can fix Ray's mess.
You can't add what we added in this application.
Which part? Math is just a description of the old matter, so therefore we should be able to add it.
It's not supported. It's not suggested in the prior application.
Oh, it's all suggested, because by the nature of the invention, it's suggested.
Patent office will never allow us to add all of that matter into the application.
Okay, but we should add as much matter that we feel comfortable with to buff up Ray's original filing.
Sometimes if you change a word or a sentence in the specification,
Yeah.
the examiner will outright reject it for new matter.
Well, who cares? He's going to reject this for insanity in the first place. And he's going to reject this as, what did you patent? Nothing?
Steve, if I'm hearing Steve right, there's very little that we can do to change the language and content of that particular...
No, you're not hearing him right, because you just said you could change all the claims whenever you want, as long as the examiner hasn't approved them. And right now, before the examiner starts looking at this and saying it's nonsense, I'd rather get the right stuff in there. Now, we can get most of this stuff in there, albeit I'm going to need good argumentation as why we can't get it all in there.
Steve, is that correct? We can change the scope of the claims of the prior application, then I think that's a good action item. It's a good thing to do. As I mentioned, it's unlikely to be able to change the specification substantially. And if we don't quite,
Well, we should throw in the word Zoom if we can.
at some point it becomes a question of, language and what language you've used. And if we start coming in and saying, well, what we really were talking about was Zoom and Pan, yeah, it's possible we could get some of those arguments through the examiner, but
Well, we sure as shit should try. Well, it looks like Ray took all this out of here.
it's not as critical as getting one good filing on like we did on Wednesday.
Well, but the date's what's important.
Right.
If it's a March one, then we have one good filing, but it's dated August 2nd. That's the difference.
But it claims priority back to
The original provisional.
the original provisional, which is before this date, again, to the extent that it
Right.
goes back there.
And that's the strategy I have been hearing is the correct approach here, is that we should be cleaning up Ray's filed patent as best as we can without adding subject matter. And I don't think we really have any new subject matter other than a macro shell to re-widget our math, which is okay. We'll leave that out. But I definitely want the underlying math, because that's just not new subject matter. That's just old subject matter defined. Old subject matter defined. And try to get as much of this in the examiner's hand as fast as we can, because that is our first patent and we'd like it to approve. And then, you know what, leave the macro in this one, and then you've got a reason that you've got new matter in this one that doesn't conflict with your old matter.
Yeah.
I mean, and that's, I sat through with Doug, went through this with Chris Wheeler, my father, I heard all of those things, and then I'm hearing that that's not our strategy. So I just want to be very specific on this so that, you know, we get that completed in time. I know there's issues to timing, etc., that we don't want to waste. Now, I'm also confused of how we particularly predicted our date as well on when this was first exhibited. According to my last notes of when you guys were down here originally, we kind of went through a timeline, and that timeline's now been changed to September, when in fact we felt it was more like April or something as the first commercial advances. And now Doug's talking to me about September dates, and I can list you 50 things that occurred before then that will be detrimental. As a matter of fact, the first one really being something like 8/10, which only gives us 6 days if my numbers are correct. You signed a license contract with Centrac to use and distribute your product. So that's well before 9/1. And these are some real critical things, but that depend on that date, if I'm not mistaken.
What contract?
Centrac license agreement was signed on 8/10.
The only thing we signed was a demo.
A demo license. Yeah, well, you were putting it up to commercialize on their site, on a public site.
But there was no charge.
But it's not a question of charge, according to Doug. Correct, Steve?
I need to have some facts.
Okay, we signed a demo to put up on a company's website, and we did our materials for public viewing so that they could identify customer response.
Oh. And when was this?
8/10.
Okay.
Now, there were conversations prior to that.
Well, the upside is we've got our application on file as of this past Wednesday.
Well, but what about changes?
We have to do it within a 1-year commercialization.
If we're not wrong, and I hate to preach to a lawyer, but that seems to be my understanding. So I'd like to get what is claimed in this one into Ray Joe as immediately. If not, you know, somehow sooner.
Well, hold on. Let him answer the question about commercialization. Would that be considered the first date of commercialization? Or a date of commercialization if there's not one prior to it?
There's not, but
Again, we have to start with the claimed invention, and
This was zoom and pan imagery that we did for him.
okay. And the inquiry is whether or not
it's video too, B. We did.
Yeah, there was video too.
Sure.
the inquiry is whether or not the claimed invention was on sale more than 1 year before the filing date of the application.
This was a test program to determine feasibility.
Yeah, that actually works in our favor. The law has recognized sort of experimental use as sort of being sort of a mitigating factor in some types of public exposure. Typically, if it's a commercialization use, or if it's to test the commercialization of the invention, they're less likely to find it to be
Well, then that's definitely what it was.
commercial use.
Yeah. Is there any difference, Steve, between we signed an agreement to do that,
Okay.
but There was no public visibility for another month.
Okay.
So which date would be the reference date?
Would you call that a sale, that agreement?
No?
Okay.
Were we ever paid anything by Centrac?
No.
No.
Never.
Okay, that certainly works in our favor. If it's not, if it wasn't an actual sale of your product. In that case, you look more at the public disclosure date.
Well, that was the public disclosure date.
No, that was September.
No, it was this date because whenever you put it up on the site publicly.
When did you put it up on the site publicly?
It was in September. Took us a while to get there.
Okay, well, no problem then, right?
But if that's the, I'm hanging my hat on a lot of things right there.
If that's the date of reference, but that,
Well, you know what? I want to beat the 8-10 day of signing a license agreement because I don't know how that's going to be construed in court, nor do I care when I can beat it right now.
Well, let me ask the question again, Elliot. Do you think that the application that we filed on Wednesday does not provide enough information to enable somebody of ordinary skill in the art to practice or to make and use what we claimed in Claim 1?
I'd argue it doesn't.
Really?
I might, just simply because the actual deployment of it or employment of it does require the correct execution of those formulas. And other than there's one particular error that is very, very difficult to understand unless you've been part of Wednesday's conversation about, the formulas. I mean, you have to reverse engineer the formulas to find out that the square root in our definition is missing. Otherwise, you'll end up with target image areas of an enormous size and be totally lost. You'll end up just having a goofy result. So, I mean, I think it could be argued that you need to be able to apply the math to create the image. It could be argued that you can conceptually create what it is that we are conceptually defining, but it's more difficult to do that without a precise understanding of the relationships of targets as subject images and viewing with this.
Well, let me turn it against you then, Jim. That's a good analysis. I think it's interesting. But let me turn it against you and say if that's true, then our August 2nd, 1999 filing doesn't provide enough disclosure to enable one of ordinary skill in the art to make this claim.
On Ray Joas?
Correct.
Yeah, that's why we want to change it before August
So you
2nd.
said the August 2nd filing. This is what we just did.
No, yeah, the March 3rd filing, you mean.
March 24th.
March 24th, whatever.
Well, I guess I'm going as early as I can, which is why we try to file on Wednesday, which is why we filed on Wednesday, so that we could get the priority of a provisional application, which, if I recall, read very much like the March 2000 application.
So the one you're referring to is the original provisional from August of 99.
Can I see that one that they
That we can, that if my argument holds, we have nothing of valid validity in that particular document.
No, what I'm telling you is that that document won't provide priority for this claim. In other words, our priority date will be Wednesday of this year, not Wednesday of last year. Or not.
Because that provisional didn't provide somebody with the art the ability to replicate what we do.
That's exactly right.
Isn't that the one we're looking for? Oh, no, that's the... No, I'm looking
Let me
for
ask you
the
this.
provisional this claims to.
Is it enough to say, and maybe I'll question my own logic now, is it enough to say that somebody understands that you create,
No, this is a separate package.
that the viewing window, that you create zoom and this create
Not the original
ability,
digital.
that to optimize
This one.
particular,
But it refers to a provisional.
before, and all we did was help them to clarify that on one day with
due
this.
date. On that day. Oh, right.
I think that's be convincing.
Okay.
You don't have to enable all ways of doing it. You just have to enable essentially one way of doing it.
Okay. Well, despite all this, I still want a firm yes or no.
Well, I think this is actually critically, we're really finally getting to the issues.
Well, yeah, we are.
Away from the rhetoric of accusations and
that's a good strategy, but yet I hear no execution strategy. And that's what I want to make 100% sure that I can get as much of what we've discovered into Ray's incompetent work, and I will call it that, as possible. And your work is far more superior. These are some issues, but there's issues. It's a large thing to grasp, and we'll get through it. But I want to change what Ray Joe has done, and that was my understanding, is we are going to take the claims we've discovered in this application you just filed and put them into that one. And that the worst that's going to happen is the examiner will approve the earlier one of Ray, and yours will fall away, the second one.
Did somebody just join this call?
No.
Did you hear that beep, beep, beep?
I did. I did hear it, but I don't know if anyone joined.
Cy?
Maybe he got off.
Yeah.
Okay.
Well, let's do this, Elliot. Let's say that you're concerned about the August 10th date. Why don't we say that we will, make some amendments to the claims in the prior filing that you're referring to, and we'll clean that up as best we can, and we'll make sure that we have the claim amendment.
This is the one he filed.
That's the provisional.
That's the provisional?
Right.
Okay.
What about correcting the map that's the one from 2 days ago?
Referring to.
Yeah, then, well, again, I don't know what was filed, so I guess
That was due on this date.
was, and it appears that I really need to consult with Doug on that.
Yeah, so if we're of the understanding that what we talked about today is what he filed, and I believe that's right,
Yeah.
then what do we do to correct that? And we should probably correct that by the 10th as well.
Okay. Right, that actually was more important where the 8-10 date comes in, because if these changes are considered to be better,
Right.
then we need to get a filing out by that date. Okay.
Okay, and Steve, just to remind you on this point, I did definitely, for a comfort level, it is to keep accusations at bay, just a letter of what's occurred, what my risks are, and what our strategies for execution are on this filing relating to as well, fixing this one, as well as relating it to Ray Joe. If you could write that clearly to us, that gives us a lot of comfort level.
Alrighty.
Okay.
Hopefully what I explained today about priority will help.
Well, this gives it the final touch of, you can rest assured, I've got it in writing. That's what I need to comfort me, that I've got a strategy, that everybody's on the same page, so to speak, so that the page doesn't shift, so that we don't get off that strategy, we all stay focused on that one sheet.
Yeah.
So that would be critical. And what is our next due date? Is that on the 10th or the 8th or something, or am I missing?
Well, the only reason the 10th has any potential bearing is because that's when the test license was.
I'd like to beat that here on this claim set. Because if we can beat the 10th here on Ray Joe's filing, that's what we need to do there, right?
That's actually not an important date for Ray Joe's filing.
Yes, it is.
An important date for the filing that we...
No, it doesn't. It's the same date. Commercialization is commercialization, and how it relates is the same here to us.
Okay.
You know what I mean?
Yeah, I guess I do.
Okay. So,
I'll make just one other general comment. Steve, everyone else knows this, but you don't. That I was just brought into this process Tuesday. It was the first time I've reviewed any patents. I've held them for Elliot in the past, but never reviewed them. And only surprised with what I found was that it was an extremely important.
but what is our next patent provision?
And at least to my understanding, we had very little time
Swept in.
to get it right, and we're now paying the price of
signed a disclosure on it, the one you gave us, encompassing him for all patents.
Alright, Jim, what's your role?
I'm the Director of Sales and Marketing.
But he's also a shareholder. Gave us, encompassing him for all patents.
Alright, Jim, what's your role?
I'm the Director of Sales and Marketing.
But he's also a shareholder.
Okay,
I've been with this since before anybody else.
I see.
It was basically me and Elliot and Guy before anybody else started, but I've never been involved in a patent review for paranoid reasons.
Now you want me to send a copy of the filings, the video filings?
Yeah, can you just fax them to him?
Sure. Let me make sure I've got this right. Okay. We've got 3 video file applications.
Do we have
We have 100 pages. Is that fine?
Yeah.
Oh, we have 4. Sorry.
Are they emailable or no?
Yeah, they are emailable.
Let's do that instead.
But then you won't have the figures. We can email it.
Email those and then just fax the figures?
Yep.
Okay, cool. The fax number is 732
Alright.
747 5569.
Alrighty.
Email is jim@iviewit.com.
And there's 5 video patents now. Correct, Steve?
I'm looking at my chart here, and there are 3 U.S. and 3 corresponding PCT applications that we wrote. Then there's a PCT video playback. That was the video playback convention.
Right.
And I think that's all.
Great. Let's get those out to Jim real quick. I'd like him reviewing those by the 8-10 day. Any changes, we're obviously going to try to revert to keep our 8-10 day as our commercialization day, giving us a little buffer if we're wrong.
Alrighty.
You know what I mean? I mean, because we don't know how people will interpret in the end what Centrac was. Right. But to beat it would definitely give us a greater argument.
Yep.
So, all right, we'll pick this up. You're going to make those changes on this patent, correct?
I'm going to wait until I speak with Doug.
Okay, great. So,
I know it was actually filed, and then we'll decide how best to proceed with amending that.
Steve, one more clarification. Did you say we have or have not had successful closure on the signing over of inventors' patents to the company?
I can't see that. Doug's working on that.
Okay, will you put that in your list of things to do? Or your strategy that gets completed?
Yeah.
yeah, and B, I just signed, as well as Brian and Jude and everybody, large thickets of documents. So Doug should have an update, Steve, as to what is exactly signed. I think it was everything, correct? And we got everybody here, so...
Yeah, I've got emails that indicate that was all done 9 months ago.
No, it was, B, but then we filed patents. And then we thought the past was done, and now these new ones had to be done. So he came here, there was notaries here, it was, you know,
Okay.
it was a lot, but let's get an update on it.
In addition to that,
You want to see it in writing?
in addition to that, everyone has individually signed a separate agreement with the company conveying, assigning to the company any intellectual property that's created as a result of their employment.
That I know.
So,
The key inventions, I just want to see that they're signed over. Because that's the value of the company right there. That's what I own stock in.
Correct. Okay. So let's changes and the date did stick at 8/10, we need to make any changes we find by 8/10, correct?
Only if the changes are so substantial that they would jeopardize the ability of ordinary skill in the art to understand.
Okay. So critical errors. Okay, if we find them.
And that's why I think, if you describe in your specification how to make one, how to do it, provide most of the details, we've done very detailed jobs throughout.
No, I agree. I agree. I see all that here.
Based on whatever we can get out of you guys in terms of describing how it works, if that's in there and it describes the claim, then there's an error, or there's an error in the math. Well, will that dramatically affect? Will that make it so that somebody can't practice the invention at all?
Right.
I don't know.
So if it's critical, if it's critical by 8/10, it should be resolved. Correct.
Oh, with the video applications, it doesn't help for us to go back and look at those. You guys go back and look at those and see if there's anything in there that you don't like.
Right. And if we find something in the claim, for example, that we don't like, we need to amend it by 8/10, right?
No,
Why?
because the claims have to be supported by the specification that's filed back on those dates, which were sometime in June.
Okay, but let's say all that fits. We also have the commercialization date.
But the commercialization date,
That doesn't relate to the claims, that relates to the specification.
So we can go change the claims.
We can change
and the claims throughout prosecution, as long as they're still supported by the specifications filed.
Right, so if we find any mistakes, we should change them, correct? In the video patents?
Yeah, as a general principle, that's a good idea.
Okay, good. All right, I think that sums up what we need. Send the letter to Cy, myself, and Brian.
That's not a complete list of what you asked for me.
What else we got? Sorry.
Okay. You've asked me to email to Jim Armstrong the 3 video applications and the playback application, the 1 playback application.
Right.
Now, with respect to the video applications, we have both PCT and U.S. filings. Do you want us to send both of those? They're essentially identical. In fact, they are identical, except the formal paperwork goes along with them.
Just one.
So the U.S.
All right, we'll send the U.S. versions of those too. And we'll fax the figures. And item number 4 is to provide a written letter to Jim Armstrong regarding the assignment status of...
Well, that's to everybody. That's to Brian, Cy, myself, Jim.
Brian, Cy, Elliot, and Jim.
Right. Just giving us the update of where we are.
I think it's something we need to communicate to all shareholders.
Well, let's get it first, and then we'll
That's what I mean.
communicate at discretion. But I think we're there.
Okay. And then in terms of general things going forward, Elliot needs to be CC'd on all correspondence relating to patents. Now, should we continue our practice of sending things to Brian?
Yeah.
Alright, so we'll continue our practice of sending things to Brian and CCing Elliot with copies.
Right, and I'd appreciate if all that email comes to iviewit.com. And therefore I have copied records.
Are you saying you only want us to correspond with you via email, not letters, not
No, but if it is emails, iviewit.com emails. Because that gives me complete copied records on tape backups.
So don't send anything to any of us at a domain name other than iviewit.com. If you send it an email.
Correct.
Oh, that's the instruction.
Yes, correct.
Don't send to any other email
appreciate your taking the blunt end of this. I really do.
Well, I just wish you would, you know...
Well, we freak out a little bit. You know, you can understand that there's a reason to freak. I'm not just making this up. So, based on that, let's try to resolve and move forward.
Thanks. Okay, anything else?
Nope. Thanks very much.
All right, good evening.
Okay, bye.
Bye.
I mean, that...
Are we aware of all the important dates? I know you probably are, but are we, Brian, made aware of all of our deadlines and contingencies relative to those deadlines that we're not left with? I was a little surprised that a final patent that's been in the works for a year, and I know you weren't involved for a year, but in the works for a year, required that Elliot and I spend the entire night and morning reviewing it in order to get...
Well, what bothers me, Doug, about that as well is that, you know,
need more time.
we go through the math and then suddenly you have a document Brian sent you several days earlier regarding the math that has a bunch of changes in it, and none of that's in there. I mean, what is it? I don't understand that.
Changed from that document anyway.
Yeah, it was changed from that document anyway. I was working with Brian, who I thought was the master of that math, but
he had sent you a updated math 3 days earlier that didn't appear in the final document that we were trying to...
Okay, I don't know. Steve was handling that. I don't know whether that, you know, Steve says he did put it in there. So I don't...
But then we go through the document that we're filing and it's not there.
Okay, but we were on the third draft when I took it over. You guys had, you know, opportunities like crazy to...
Okay, but that's the thing. Brian had sent it to you earlier, and it still wasn't appearing in final drafts.
If that's true, then something crossed in the email, because Steve said he put it in there, and maybe there's a piece of the math missing between the crossing the email. But you're right in terms of...
Is Steve there?
I don't know. He probably is.
I mean, and my other question is a simple question my dad asked about electrical engineers being mathematicians, and said, you know, didn't they sit and do the pencil out the math of all this themselves?
Here's what happened on that, and I really gotta go, guys. Steve was preparing the application. We worked with Brian and you, Elliot, on the application. In some of the letters and emails, he said that he doesn't understand the math. He can't.
I'm not getting any of those.
Huh?
I'm not getting any of those emails.
Well, then talk to Brian. Because we were corresponding with Brian on that. And I don't know why you weren't getting it, if that was the case, or if we were, I don't know which letter went to who, blah, blah, blah. But I do know that we mentioned that we didn't understand the math, and we were up to the third draft, if I recall. And you're right, Jim, that it shouldn't have taken, you know, it shouldn't have, you know, been last minute, and you should have had time to do it. I totally agree, but I can't take total blame for that.
Well, but wait a minute. Steve has fundamental errors on understanding the math, and yet we're going to file it with him having math problems?
It's your duty to either help us understand...
But then I've got a point. We did help you. We sat on the phone for an entire day, walked through this.
The day of the filing, you mean? You helped?
And if this math is still wrong, there's something really fundamentally wrong here.
Let me check it again.
Okay, yeah, let us call you back in a while. Steve in today, too?
I didn't get involved until Wednesday, so...
Right.
But I tell you one thing, Doug, that you should do is just a matter of course going forward. Elliot being the owner of the company and the person that Brian reports to, is any future email correspondence whatsoever should always be copied to him. That's kind of just a standard practice we all do in the company.
To copy?
Yeah.
Okay. No, I didn't
You're
know
asking
that.
me to review and sign these patents, and you're not sending me information. What do you mean?
Because I think had we known that there was a question of...
In the math, some point either today, Monday, with a few of the key people in the company who are investors, et cetera, so that they understand what they're investing or not investing in.
Don't jump to conclusions. Let's look.
No, I know I'm not, B, but if this is correct, we've got some fundamental things that need to be discussed.
If what's correct?
If he's correct about the math being wrong. But let's check that.
No, I'll bet we could get a good patent if the math is totally wrong. I think we're barking up a tree here that's not a big...
Well, but wait a minute. The question is, if it still remains wrong, and we gave you the right changes, it should have been filed right. And then all of a sudden, I'm left with a patent.
Okay, talk to Brian.
I will.
Ian gave me the right changes. I filed what Brian gave me.
Okay.
And I don't mean to,
No, I
yell out at that, but that's what happened.
That's no problem.
Totally hear that.
Okay?
Thanks, Doug.
Okay. Bye-bye. Talk to you Monday.
Close this door. 842,000, 8:30, Doug Baum, conference call, Jim Armstrong, LA Bronson.
Yeah. I can hear you better now.
Okay,
I couldn't hear anything.
Steve, Jim, everybody, I'm taping the conversation, 8-4 patent discussion regarding docket 57, 103-120, Brian Utley, Steve Becker, Jim Armstrong, Cy, Bernstein, and Elliott. Okay, guys.
On this end, too, if that's all right with everybody.
Yeah, did you get the fax from Jim?
I haven't received it yet.
It was sent to, actually to Doug, but on the CC line, went to a machine 297-4900.
That's right.
Okay.
That'll go to our central fax department, and I just phoned up there and asked them to deliver that to me when it comes in.
Okay, but you've got the patent in front of you?
I don't, but I can get it.
Okay. So let's do that.
All right, I'll need a minute. I need to go over to Doug's office.
Okay.
So the fax is on its way to you now.
It's on the way to me?
Yeah.
Okay, then I'm going to put you guys on hold.
Well, it's not done yet.
That's all right, but I got to go upstairs and get it, so
Okay.
hold on.
Numbers don't matter.
They didn't put
And we corrected that.
yeah. And I did it again on Wednesday night.
And he said to me all these changes were in, and I went through them at 11:15 at night with him, so all the math has been changed. I was looking at them, I said, these haven't been changed. He said, no, I'm working on a copy that's been changed. I'm going to send it to Brian and
I
sign off, and so well, now again we're back at this same kind of thing. How do we change things? What effects does it have on us?
This has no effect mathematically. That's
Large fax?
Yes.
Oh, okay.
9 pages.
but obviously this has an effect.
A huge effect. It gives you a completely altered number.
Well, you could explain it, because the only way you could derive this is by having that be the square root.
But this is wrong that he missed this.
I know.
Wait, and isn't that on your current math? Do you have your sheet that you did current math, but he said he didn't have, had, whatever? Brian, do you have the patent book? Yeah. Okay. I need to borrow that.
I mean, I think in a patent document, being as important to us as it is, there's not an acceptable level of error. It's either got to be all right, or it's not acceptable.
Well, and that's what we heard from Doug this morning. So you an example. Is 2,560,000 times 0.8 the same as 2,560,000 times 1.25? Yes or no?
I doubt it.
Okay. Well, that's the fucking issue. Okay, that's how far off these are.
Okay.
This is Steve. I'm back, and I can't seem to find that file. Doug is out today. You guys may know. So I don't know how much help I'm going to be.
Okay, well, do you have the facts?
I'm still waiting for that.
Hey, B-Man, you got the file right there. Just email it to him.
But here it is. I've got the facts now.
Okay.
Okay.
Now, Steve, Doug also mentioned that you had emailed some correspondence to us that you didn't think the math was right earlier. I have no records of any of this.
No, what I did is I faxed the draft over on Monday night, which incorporated some additional disclosure that Brian had sent. Basically, it was examples. He had the equations set out for both print film and digital examples, and then he had 3 examples for print film and 1 example for the digital. And I exactly basically cut and pasted that into the application.
Well, the application we got from Doug didn't have any of that. Cut and paste. Because what it had was the old stuff, and Brian referred to having sent this to you several days earlier, and yet it wasn't in there.
Yeah, I don't really know, because then at that point, Doug was down there with you guys, and I presumed you were reviewing it on like Tuesday and Wednesday, and then Doug said he would take care of just, because we figured there would just be some minor changes after we'd incorporate all that.
Well, it wasn't incorporated, so there were huge changes.
Oh.
And it would have been filed completely wrong had it not been for Jim Armstrong reviewing it. Everybody would have nodded off on this and accepted wrong, completely wrong filings.
Maybe he should be part of this conversation.
He's on this conversation.
Oh, good. Hi, Brian.
Hey, hi, Steve.
Brian's here and Jim Armstrong's here.
Okay. Well, the only link we're missing here is Doug, because Doug took the last few steps of incorporating comments and actually filing the application on Wednesday.
Hey, B-Man, forward him a copy of the final draft, would you?
In the end, Steve, I think the most important question to have answered is what are our rights and obligations and opportunities relative to correcting this without any ill effects to us?
Yeah. There's plenty of opportunity, essentially. We can file, if there's, substantial errors in the application as it was filed, we can simply file a new application, as soon as we get those fixed, either on Monday or Tuesday or what have you. The goal of filing on Wednesday was to maintain priority back to the provisional application, which was filed a year ago.
So did we lose that if they're wrong?
No, because we can only claim priority back to the extent that the subject matter was originally disclosed in the provisional filing of August 2nd of last year, and none of these equations were filed back then.
But the original process was.
Right. And the original process is preserved in the application. We're just talking about the details of, the math examples that are in here. So we haven't lost anything.
Well, we lose claiming back to the priority of the original provisional. So that we did lose something, or am I incorrect in what I'm hearing?
Yeah, no, we didn't lose. The original provisional can only provide priority for what was originally disclosed. And the math was not originally disclosed, right?
Well, no, but the math is a subject of the invention, not vice versa.
Right. Yeah, the reason of putting the math in there is essentially to provide, concrete examples
of the invention.
Right.
The invention was in there as of the priority date, and we had already talked with Chris